Good evening, everyone. Welcome to tonight's John Austin seminar. My name is George Letsas, and I'm a professor of legal philosophy here at UCL. And I'm delighted to welcome tonight's speaker, Professor Guillaume Tusseau. We are really honored by the opportunity to listen to his work. Guillaume has been professor of public law at Sciences Po since 2010. He's a member of the Institut Universitaire de France, and he holds an honorary doctorate from the Universidad Privada Antonio Guillermo in Peru. He was a member of the Conseil Supérieur de la Magistrature between 2015 and 2019. He was head of the law department at Sciences Po until 2024, and he's currently director of the research center at the Sciences Po Law School. Guillaume's interests are impressively wide. I won't go through his publications here with you, but he's a specialist in both constitutional law, particularly in the field of comparative constitutional law, but also an accomplished legal theorist, particularly in the work and thought of Jeremy Bentham. He's the founding member of the Bentham Center, and he chose today to speak on this particular area of his expertise. The topic for today is digital constitutionalism, and debating that topic from a Benthamite perspective. We are really grateful for the time he made to come to London from Paris. And without further ado, I'd like to hand over the floor to Guillaume. Thank you so much for being here.
Thank you so much, George. I'm the one honored here, and it's a pleasure and an honor to be here, to be invited to present my thoughts, my doubts, my hypothesis on during a John Austin seminar. And as everyone can guess, being in Bentham House means a lot to me. So what I would like to do today, just in a nutshell, is to make two claims. The first on the knowledge they have of one's behavior, the knowledge they have of the weather, for example, if it is about regulations, traffic regulations. So based on this updated knowledge, are able to issue very specific, very narrow, tailored regulations. So this is also something that affects one of the three traditional branches of power. And regarding legislation, frequently, increasingly frequently, members of parliaments recognize that they've been using ChatGPT or any kind of other device to draft legislative amendments. Artificial intelligence is also used sometimes to ensure the coherence of legislation. Parliaments during the COVID crisis have been using remote meetings. Tools that enhance political participation can depend also on the digital, and also there are great risks because of the risk of filter bubble, the risk that algorithmic selection leads one to see only recommendations that are coherent with what they have already been consulting, leads to to undermine pluralism and to polarize increasingly political discourse. So sometimes what is at stake is what the digital does to constitutionalism or constitutional law. Sometimes the discussion is about what constitutional law does to the digital. But in all these elements, or in all these discussions, the constitutional law aspect and the digital aspect can remain conceptually separable from one another. Conversely, there are other contexts, the ones on which I want to focus now, in which understanding the expression digital constitutionalism implies a form of confusion or a form of fusion between constitutional law on the one hand and digitalism. And in this case, there is no accidental conjunction between the two, but something more essential. And my claim is that if we want to go beyond a simple, suggestive allegory. And if this discourse of digital constitutionalism is to be taken seriously, which is by no means mandatory, when it claims to bring together or even merge constitutionalism and digital technology, well, it is necessary to attempt to elucidate the meaning that constitutional vocabulary can have in this context, and to grasp which concept of constitutional law is implicit in this discourse, or may be appropriate to understand this discourse and identify precisely what claims it makes in a more or less implicit or under-theorized way. And my suggestion is that it's not. I know. Is that Jeremy Bentham might have something to say about this, and suggestions to make about guaranteeing fundamental rights, separating powers, and some of the fears, the concerns digital constitutionalism gives rise to. So the outline of the discussion will be the following. I will first present digital constitutionalism and the strongest forms of digital constitutionalisms, not the ones I've been mentioning so far, and see what Bentham can contribute to the current discussion, the current puzzle, the current concern about digital constitutionalism. So beyond accident, that is, in situations where there is a stronger connection between digitalism and constitutionalism, in the cases where it is difficult to separate them, we can have two main possibilities. First, sui generis forms of constitutionalism. These new forms of constitutionalism emerge, and they are frequently presented in the discussion as spontaneous forms of constitutionalization. And this is one of the most remarkable aspects of the discussion. And Gunther Teubner is the one who has been offering the most developed theory, the most self-contained theory about this kind of phenomena. According to him, we are with a curious phenomenon, that of self-constitutionalization without a state. And according to him, sectors of global society, tourism, contracts in the law of construction, sports law, and digital law begin to develop sectorial constitutions, pressing social problems within self-governing world systems, generate social conflicts, which result in legal norms. These norms begin to enjoy a kind of stability. They are enforced by judges or legal jurisdictional or authorities, and they follow a kind of hierarchy. So according to Teubner, there is a kind of sectorial development of sectorial constitutions of the global society. Other scholars share his views, and for example, Nicholas Suzor in the book called Lawless also describes the emergence, the self-constitutionalization of those spheres, and especially the sphere of digital law. So according to them, organs like the ICANN, the private body that regulates the internet, firms like Facebook, Google, Amazon, Apple, etc., are the main actors of digital constitutionalism. And according to those authors, sovereignty has truly shifted from the public to the private sphere. And now some fundamental rights, like the right to free speech, are no longer directly regulated by states, but they are regulated by those private actors to whom what was traditionally a public function was delegated. So the transfer of sovereignty is also the transfer from the nation states to transnational regimes which have no specific geographic connections. And some of those private actors truly adopt the vernacular of constitutionalism. So, for example, we have the example of BitNation. BitNation is presented as a private, totally independent from the state nation. It works with the technology, the blockchain technology, and the actors in a totally decentralized way, that is, individuals form contracts. There are marriages, there are birth certificates, and Estonia has been in contact with the BitNation in order to secure the digitalization. This country is at the forefront of digitalization of its public sphere, constitutional law, administrative law. And there is this constitution of BitNation, which is known as Pangé. And it is sometimes compared, well, the way it works, as a totally free, decentralized, stateless form of self-constitutionalization, ensuring the security and the reliability of information storage and circulation, because the users themselves certify what has been done, the transactions that have been done previously. Another major actor in the field is Mark Zuckerberg. Meta, formerly Facebook, created the Oversight Board. This body was created in 2018 in order to review content moderation practices made by Facebook and Instagram. And Mark Zuckerberg directly draws the parallel between his Oversight Board, which is a private advisory body, and the Supreme Court, and of course the Supreme Court of the United States. So, where is it? So maybe false that Facebook make the first decision based on the community standards that are outlined, and then people can get a second opinion. That's a right of appeal when you want to call into question the validity, the proportionality of a decision that moderates content. You can imagine some sort of structure almost like a Supreme Court that is made up of independent folks who don't work for Facebook. So we can believe in this discourse, we can reject it. The fact is that he's borrowing the rhetoric of constitutional law about a purely private entity, which testifies to the self-constitutionalization of these actors. The first decisions the board made also testified to a process of self-constitutionalization. Initially, it had only to enforce Meta's norms, the charter and internal documents of the firm. And progressively, it decided to enforce as well the United Nations guiding principles on business and human rights, as well as several human rights treaties. And it was not long before these decisions were compared with a kind of digital Marbury versus Madison, with a form of self-empowerment of the Oversight Board. So once again, the vernacular, the mindset of constitutionalism is applied to those purely private entities. And this spontaneous thematic constitutionalization is intrinsic to the phenomenon. It is it is difficult to distinguish between constitutionalism on the one hand and digital technology on the other. And there is another big issue in the discussion, which is code is constitutional law. That's the sentence to describe the kind of normativity that emerges from the digital sphere. So here we can oppose Kelsen and Lawrence Lessig. So if we follow Kelsen, a norm is something that says what ought to be, that is the Sollen, as opposed to the Sein, as opposed to what is. So by definition, a norm can only regulate a behavior that is neither necessary nor impossible. This behavior has to be contingent. And in normal, traditional legal normativity, there is always the possibility of disobedience. That is, there is always room for choice for the individual. Well, in the digital environment, in order to capture this idea, Lawrence Lessig invented the sentence, code is law. The influence of the digital environment on behavior is different. and the choices that are made by those who design the digital environment, those who design the platforms, those who design the social networks, make things simply possible or impossible. Well, you have no choice. If you want to use Facebook, if you want to use Instagram, if you want to use those devices, well, you have no choice. You need to comply. It's just like if we were out of the normative, the deontic space, and embedded in the anankastic space. So, for example, if you want to cook a cake, well, there is a recipe. Well, you have no choice. Once you have decided to cook the cake, you have to follow the recipe. So the norm here is in terms of physical constraints. It's a normativity that doesn't leave any room for choice. So in spite of the fact that disobedience and contestability are characteristics of law in democratic and constitutional settings, in the digital environment, it appears to disappear. So the room for disobedience, for political autonomy, is also disappearing. So according to Diver, to whom I will return later, this represents, I quote, the apogee of legalism. The normative merges with the descriptive. What is required simply becomes what is. And what is all the more frightening is that this necessity, this inescapability, is created, is designed by human beings, by artificially created. So there is a kind of physics of human behavior that emerges in the normative of the digital sphere. And this is what Turner calls the self-enforcing nature of the code. There is no room for disobedience. We simply are submitted to the mechanism of digital constitutionalism, of digital law. Another major source of concern in the digital sphere is the dissolution of the separation of powers. Needless to say, this is a notion that is crucial to ordinary constitutionalism, but this is the way digital governance works. Generally, you have a form of legislation or an analogon to legislation, which is the terms and conditions to which we subscribe when we accept using some digital device. These are contrat d'adhésion, where the weaker party, the user, the consumer, can simply accept the proposed terms and not discuss them in any substantive way if he or she wants to use the said device. And those terms and conditions are often presented in a way that makes it very unlikely that they are read and analyzed in a serious way. So this increases the dimension of unilateralism in this form of legislation. And who enforces those terms and conditions? The legislation of the digital actor, the digital actor itself, by providing for normative and technical means that ensure compliance with the terms. And especially if we're thinking about social networks, by the moderation policy. So this autonomy of platform is generally protected constitutionally, but in normal constitutional sphere, by the right to freedom of expression. So the state has to withdraw from this space of social interaction precisely because it needs to protect freedom of expression. But this means delegating to private entities the regulation of free speech. Contractual freedom and property rights complete the basis for this power of digital platforms and digital actors. And the most relevant authors in digital constitutional theory suggest that this apparently purely contractual instrument constitutes in reality an instrument of governance. So it's a new shift in the paradigm. And this may very well lead to forms of digital despotism. So regardless of the methodology that is used by actors who rely on content moderation, notification, taking down of a content, removal procedures, human control, algorithmic moderation, or mixed procedures, where the platform retains control about the contents that are used. The platform is the actor that that assesses the proportionality between the rights of the user, the rights of the person who's displeased by the content, the right of the person who put the content online, etc. So once again, a public function seems to have been delegated to these actors. And the difference lies in the fact that in normal constitutional law, well, you still have the separation of powers. The one that legislates is not the same one as the one that executes, and not the same one as the one who makes judicial decisions. Whereas in the digital sphere, apparently, the same actor enacts legislation, enforces it, and decides about individual cases. So according to some authors, this leads to a form of algocracy, which is no different than a pure confusion of power. That is the definition, the traditional definition in the 18th century of pure despotism. So this is the general presentation of digital constitutionalism. What can Bentham contribute to the discussion? So the first side of Bentham's contribution is, of course, the panoptism. Bentham is frequently mentioned in the discussion about digital law, digital constitutionalism, for his contribution to the theory of massive surveillance. So the panopticon, which was then later the object of a video game, is the situation where everything is recorded, everything is monitored, everything is controlled. And Bentham's name is frequently associated with this aspect of digital constitutionalism: mass surveillance, disregard for autonomy and privacy, massive data recording, etc. My feeling is that Bentham is not only part of the problem, but can also be part of the solution. So, and I would like to substantiate that claim from two perspectives. So first of all, Bentham's concept of constitutional law may be helpful in making sense of the discussion about digital constitutionalism, if one wants to make sense of that discussion and take seriously all this literature that has been emerging. So it is widely known that, unlike his disciple John Austin, who considered constitutional law as morality, positive morality, Bentham has always regarded constitutional law as law properly so-called. And I think historically he's the first one to have made this claim and to have talked in a consistent way and systematic way about constitutional law as law. So this can be proved through his traditional definition of a law, his classical definition of a law as an assemblage of signs declarative of volition, conceived or adopted by the sovereign in a state, concerning the conduct to be observed in a certain case by a certain person or class of persons, etc., etc. And it is clear that constitutional law rules perfectly fit in that definition. The only difference is that their addressee is not the people at large, but the sovereign. That accounts for the difference between leges in subditos or leges in populum, and on the one hand, and on the other hand, leges in principe. Secondly, the main difference between ordinary norms, ordinary laws, and constitutional laws is the sanction they rely on. So according to this quote from Limits, Bentham insists on the fact that for constitutional law, it's difficult to use physical sanctions or political sanctions, but moral and religious sanctions can very well be used to ensure the force of constitutional law and to ensure that the sovereign complies with the requirements of constitutional laws. So the force of constitutional law must be, well, Bentham's theory of the force of constitutional law must be connected with his conception of sovereignty. Since the fragment of government made clear that sovereignty is not a metaphysical entity, but the result of facts, that is a purely sociological, empirical, psychological phenomenon, basically related to a habit and a disposition to obey. So the popular sanction, which is the result of the spontaneous disposition of every man, every individual, is what contributes to sovereignty, that is, to the establishment, reinforcement, continuity, limitation, and possibly the fall of the sovereign. So just as the individuals compare every day the utility of complying with the law produced by the sovereign and the utility of ignoring that same law, the sovereign compares every day the utility of imposing this or that duty, conferring this or that right, and the probability of being followed, obeyed, or on the contrary, being ignored. This probability itself is nothing else than the willingness of the people to obey the orders of the sovereign, that is, their habits and their disposition to obey, that is, constitutional law. Laurent Vendor has explained in a very, very good way this interpretive conception of constitutional limits that appears in Bentham. Those limits are determined and implemented by collective popular judgment. That is, laws in principem, constitutional law norms, are the result of the political community's continuous evolving, dynamic, critical, interactive, and discursive utilitarian evaluation of the actions of the ruling few. For all this, one actor that is crucial to Bentham's legal theory is the public opinion tribunal. And it is something that can very well be equivalent to a figure that appears in some parts of the digital constitutionalism literature called citizens of the cyberspace, or in other books, the people of the internet. So in his constitutional and political theory, Bentham always seeks to maximize opportunity for this institution to express popular and moral sanction. So this is my ontological claim, or my claim regarding the possibility to make sense of the ontology of digital constitutionalism. This approach to integrating constitutional law as an integral part of legal phenomena in Bentham's writings proves to be fruitfully applicable to the digital environment, and it makes it possible to explain the conceptual apparatus of digital constitutionalists. Now, regarding the second claim, more related to the axiological preoccupations of digital constitutionalists, I think Bentham can also be fruitfully used in order to address the main concerns of the power private entities have secured in contemporary societies. So if we transpose Bentham's concept to the digital environment, we can see that he offers at least some elements, some tools to deal with algocracy, or to deal with this kind of digital despotism which emerges. First of all, ex post, the control that rests on the ruling few and ensures that the ruling few pursue the greatest happiness of the greatest number is mainly exercised in Bentham's theory by the public opinion tribunal. And I rely on this quotation, which is, according to me, one of the most fantastic sentences Bentham ever wrote. Public opinion may be considered as a system of law emanating from the body of the people. This idea that public opinion may be regarded as a system of law is a truly fascinating insight. It bears, of course, the mark of Bentham's epistemic pan-legalism, as I have called it in other works. But here it may very well be a good tool for digital constitutionalists. So Bentham's theory is, of course, related to state constitutionalism, although it doesn't use very frequently the term state. His conception of constitutional law is, according to me, liberal enough in conceptual terms to deal with a wide variety of social phenomena. In this general context, I have described of constitutional leveling, placing public opinion on the same level as the other powers that have emerged in the digital sphere, is a way of articulating with them the involvement of citizens, associations, NGOs in digital governance. And there have been some examples of situations where public opinion has been able to influence digital actors. For example, in 2020, the Stop Hate for Profit campaign was launched against Facebook, against Facebook's refusal to remove a post in which Donald Trump threatened protesters after the death of George Floyd. Companies such as Coca-Cola, Unilever, the North Face, Verizon suspended their posts on the network, thereby exerting what has been presenting as a form of organized social pressure. Another example is the way the organization Women, Action, and the Media made the public's voice heard regarding Twitter's practices, and it also demonstrates the effectiveness of the procedure. Another illustration of what can be regarded as a constitutional resistance movement on the part of the digital public is the decision by many Twitter users or ex-users to switch to another service when they learned about Elon Musk's takeover of the company. And it has been calculated that just after the takeover, half of Twitter's top 100 advertisers appeared to have stopped advertising on the website, making the firm lose money. So this is a type of Benthamite constitutionalism of public opinion, and it could be a means of ensuring the application of human rights values and the separation of powers in the digital sphere. For example, Turner has already theorized constitutional counter strategies, resistibility, and contestability in the digital sphere. And he thinks that profit-threatening strategies are the most promising ones, the most efficient. Of course, the effectiveness of these practices is debatable, and the way self-regulation, which remains the dominant paradigm in the United States, works and its limitations can be criticized. But nevertheless, Bentham's idea of the public opinion tribunal and the committees of the public opinion tribunal may help capture this new way to limit power in the digital public sphere. And what we are witnessing, the heart of the crux of the matter in the digital public sphere, intrinsic to its origins and development, illustrates a very classical problem Bentham has been facing, which is reconciling interest and duty. And this principle is at the heart of Bentham's constitutionalism, whose ambition is to design an institutional framework such that the ruling few in power are incentivized to seek the greatest happiness of the greatest number. So these campaigns have proved to be able to do just that in their limited way. Sometimes some private entities attempt to formalize public opinion committees or committees of the public opinion tribunal. So, for example, Twitter and YouTube grant authorized reporters or trusted flaggers a special status that allows them to identify and report more efficiently inappropriate content on behalf of the others, making moderation practices more popular and more accurate, more effective, and more participatory. This is also what has been proposed by the European Digital Service Act about trusted flaggers. Recently, another strategy that has been proposed is the creation of equivalents to Bentham's committees of the Public Opinion Tribunal. The idea is to promote the involvement of all stakeholders, governments, users, employees of the digital firms, producers, designers of services, etc., in the governance of the digital domain. In Taiwan, a digital intermediary service bill has been proposed in 2022 in this perspective. And the idea was to create a multi-stakeholder committee that would help platforms establish codes and self-regulatory mechanisms. So it would also have offered a forum for public and private discussion representing the government, the industry, citizens, academic, legal firms, financial firms, technology firms, etc. Telling me the bill has not been adopted. In France, it has been also proposed by several organs to create these kind of councils that the association Article 19 proposes to call social media councils. And you can see all the functions those social media councils should have. Review individual content moderation, provide general guidance on content moderation, act as a forum where all stakeholders can discuss, use a voluntary compliance approach. So these are very similar to the organization of small public opinion tribunals. Another author, Golder, expands on these initiatives and is in a book called the Leviathan, the New Leviathan, proposes to organize a whole hierarchy of social media councils or citizen governance councils. So this is ex post, but ex ante. Digital constitutionalists also have the ambition in a context where the idea code is law prevails to offer the public opinion tribunal the opportunity to intervene before the technology is deployed. That is, to intervene at the design stage of the technology. So this is, for example, what the Global Network Initiative tries to do, offering a very interesting example of cooperation between industry, human rights groups, academics, investors, to share information and promote industry standards that protect human rights. So the basic idea is to incorporate the values of traditional constitutionalism, the values of separation of powers, moderation of powers, human rights at the design stage. And Diver goes even further in his theory of jurisprudence. He proposes to, à la Bentham, to make everybody his own lawyer, but here it would be to make everybody his own digital lawyer, his own digital constitutional lawyer. So he wants to ensure that the values of constitutionalism are integrated in the fabric of the code itself and integrated in the professional training of those who create programs and of those who create the programs that are used to create the program. So it's a very wide ambition there that is proposed, that lies at the heart of the project of jurisprudence. So they want to propose what they call a due process inspired, human rights sensitive, participatory, and accountable way to produce the code. So what they want to secure in a situation where code is law, where we have this kind of specific normativity, is to make it possible for the users to choose again. So they want to minimize opacity, they want to minimize immediacy, so they want to introduce what they call desirable inefficiency. They want to slow the pace of the code. They want to limit the unchangeability of some devices and increase the idea of justification of all those devices. So, of course, it might claim that Bentham can be used to make sense of the ontological problems or topics digital constitutionalists are dealing with, and of the axiological problems they are facing. There is a certain measure of optimism. Of course, public opinion is not a unitary group nor a monolithic coalition, and Bentham precisely makes sense of that by identifying various committees in the public opinion tribunal. And moreover, Bentham is by no means naive about the possibilities of manipulating public opinion, and this is a major problem in the digital sphere. So his empirically inspired and evidence-based ethics of public discourse, as well as his theory of public fallacies, can very well also be resources in the contemporary struggles of digital constitutionalism. So this ultimate avatar of constitutionalism that digital constitutionalism represents, therefore, undoubtedly deserves to be explored in the light of Bentham's vision of power, to which technology gives its full relevance, and his vision of the legal shaping of power, the legal design of power, the full dimension of which is expressed in his epistemic panlegalism, is also relevant. And this is precisely one of the ambitions of the new project of the Centre Bentham, the Pan-Bentham project, which we're going to develop from this year onwards, that may help clarify to what extent Bentham is relevant. Thank you very much.
Right, thank you, Guillaume, for this very rich and thought-provoking presentation. I think listening to you, there were like three main key steps in your presentation. The first one was a largely descriptive account of how digital technology marks a shift away from the public to the private in a way that escapes constraints of the Constitution as we know them traditionally. So these platforms are decentralized, they operate outside the state, they have their own constitution. So there was a depiction of a problem there. So the first part was detailing the ways in which this phenomena challenge traditional accounts of constitutionalism, and that's a problem. Then you moved on to Bentham and explained how, in his theory, constitutional law is linked to the public opinion as conceptually, normatively, that the constitution of the Constitution is meant to ultimately be linked back to the people in that particular way. And then you mobilized or applied that theory to suggest solutions to constitutionalism. So where you think Bentham's theory can bring back the Constitution to where it should be. But there are these three key steps in your argument. So the problem, Bentham's theory, and then the application to the problem. So I think that was really, really well argued. So that leaves me with asking everyone to join me in thanking Guillaume for a really, really, really thought-provoking and rich discussion. Thank you so much for coming.
Thank you.